That the bill be read the second time. The honourable member for Nelson.
Mr President, I thank the government for bringing this amendment bill and all the work that went into preparing it. I regard the protection of children in our community as a shared responsibility of the highest importance for all citizens, and most especially for those of us here who have the opportunity to create the most robust legislative protections and access to justice for our children and, in fact, all members of our community. The Royal Commission has provided us with recommendations on how we might legislate, not only to help protect our children and prevent abuse, but also to improve the investigation, prosecution, sentencing of perpetrators, and with respect and acknowledgement of all victims of child abuse, improve their access to justice and support. I'm very pleased to see solid consensus on progressing this in Tasmania across politicians from all parties and in both places. Today I would add my support to this bill, and firstly I would note that the amendments are not primarily designed to act as a prosecutorial tool, as we've been told, but to be protective of vulnerable children and to heighten protection, both for those children who have already been victimised, but also for averting abuse from beginning. In making these amendments, we're aiming to prevent abuse from occurring. That's really important, but it is also highly important to be able to act as quickly as possible once abuse has occurred to curtail it. So to briefly mention some of the changes and additions that I want to speak in support of before talking a little bit more in detail about some others. The creation of the new crime of failure to report. I believe this creates a more robust assurance that appropriate action will be taken when a disclosure is made. It better indicates the gravity that we would regard such a failure to be, the gravity of that and the expectation that it should never occur. Disclosure is made and a report is made and acted on. The main purpose of this new crime of failure to report is to protect children and to stop abuse continuing in the spirit of all these amendments. The fact that there's reasonable belief requirement means that it's not going to be taken lightly. The fact that I note that there are other appropriate protections around not applying to children who receive information, around not applying if the report is made by a victim who is now an adult and doesn't wish that disclosure to be made public, and around the fact that it must be actioned only under the DPP. And requires a fairly high bar there to be acted on. So I support that creation of that new crime of failure to report. The extension of grooming offences, I think, better captures those situations we know to exist in relation to grooming behaviour and is an excellent addition. The targeting of family members as an avenue to obtaining access to a child is well documented and known, and being able to better capture that under the grooming offences is an excellent addition. And likewise, the changes made around strengthening evidence-giving measures, pre-recorded audiovisual evidence as a tool to be used in all child sexual abuse trials is highly sensible and compassionate as a measure to minimise the trauma of multiple trials and multiple instances of having to give evidence. So I think that's an excellent addition. I'm very pleased to see the inclusion of members of Parliament as mandatory reporters. I see this as entirely appropriate, and as a very new member, I haven't yet been in a position to have to enact that sort of action. But my understanding from colleagues is that there may well be times that as members we're made aware of or encounter situations where child abuse may be occurring, and I think that's very important that we are included as mandatory reporters. I think that with this new requirement, I would certainly look forward to all of us in this chamber being provided with guidance on the appropriate actions and process to undertake in those circumstances. And I hope that we can work on having that guidance provided. I take comfort actually from the fact that the changes made in this amendments bill mean that Tasmania will have one of the most extensive lists of occupations requiring mandatory reporting in the country. I think that's an excellent point of progress for us. I do note, interestingly, that the Northern Territory simply requires all adults to report, and I think that there's merit in that approach also. Which brings us to the point of discussion that has had more discussion around it in the public domain and here today, and that's the inclusion of members of religious ministry as mandatory reporters, and in doing so removing the seal of the confessional. On that, may I say that while I understand the sensitivity of this matter for some members of the Catholic Church, and indeed I too was raised in the Catholic Church, so I have an intimate understanding of that from my very earliest times. But even understanding that sensitivity, I believe fundamentally that it's not incumbent on us as secular legislators to prioritise the preservation of a religious practice above our responsibility to act in the best interests of our community, and I would say especially in the best interests of vulnerable children. I note that there are a range of objections from the Catholic Church nationally and also here locally, including through the Tasmanian Catholic Archbishop. I note that he's claimed that the legislation could lead to disharmony between state and federal laws in the future. Clearly that's not the case. We know that many states and territories are already acting on this in a concerted way to legislate mandatory reporting laws and removing religious exemptions. We know ACT have moved in that direction, WA, Victoria also, so we are one amongst many. In fact, I would say what we're doing is bringing ourselves into harmony with a concerted national approach and consensus. However, it would be my assertion that even were other states not yet moving on this, I would wholeheartedly be in support of Tasmania taking the lead and acting on it as promptly as possible. There should not be an impediment to doing the right thing as early as possible when it comes to protecting vulnerable children by saying, well, we don't want to be first. So the sooner we act, the more opportunity we have to offer better protection to our children. Another objection that has been raised by the Catholic Church is that these measures impinge upon religious freedom and the sanctity of the confessional. Despite national rhetoric around religious freedom at the moment, it's been pleasing to see both sides of the political divide and many independents here in Tasmania join together to acknowledge that the protection of children is paramount and there are no exceptions to mandatory reporting, religious or otherwise. Freedom of religion has been raised. There's been discussion from the member for Murchison and others around the sections of the Tasmanian Constitution and our national laws that relate to that. I believe that the matter of religious freedom has been well prosecuted and been shown to be not an argument to defend the secrecy of the confessional. I would fully recognise the thorough coverage given to this by the Attorney-General in her summing up of the debate in the other place as to why this argument holds no water, and I won't be repeating that here other than to add my support to those arguments. Something we may bear in mind is that the intent of these amendments in this bill is not primarily designed to act as a prosecutorial tool, but it's to be protective of vulnerable children. My understanding is that the evidence from the Royal Commission indicates that the secrecy of the confessional, historically, rather than providing an avenue to curtail sexual abuse of children, has in fact served to enable its continuation, in many cases for decades. That is, despite multiple instances of the perpetrators receiving the sacrament of confession, their abuse of children continued and in many cases was enabled to do so because of the comfort provided by the confessional, the sacrament of confession. This is highly relevant in my mind to whether this is a defensible position to claim the continuance of secrecy when it comes to the confessional. There's a range of other points that have been raised by the Catholic Church on this matter. They've talked about, and the member for Murchison went into a little bit of detail around this, that Catholic Church is taking its own measures in regards to safeguarding and coming up with guidelines. That's good, but it's not good enough. There's nothing satisfactory for us as secular legislators in our own justice system. There's nothing satisfactory about internal measures being taken and safeguards being taken within the Catholic Church. It wasn't good enough in times past, it isn't good enough now, and it holds no water for our arguments here. Another point that's put forward is that confidentiality is essential for the sanctity of the sacrament of confession. This is entirely immaterial for our purposes as legislators in a secular society. It's not for us as legislators to maintain any aspect of any religious practice in this country. It's also been said that confidentiality within the confessional process is comparable to other professions that have a client confidentiality arrangement. And the example put forward is lawyers. That's certainly the one that's been put to us in the briefings and the situations I've attended. I think we could quite rightly note that doctors aren't used as an example here, because we know that the patient-doctor confidentiality is absolutely trumped by mandatory reporting. Doctors are mandatory reporters. They cannot claim confidentiality as a reason not to report. So, of course, the Church can't use doctors as an example and doesn't. They use lawyers instead. However, the lawyer-client confidentiality is not absolute either. It has clear parameters. It extends as far as information received for the purposes of obtaining legal advice, and doesn't extend beyond that. So I think there's no comfort there for the Church to try and compare itself to lawyers or other professions. Also, quite frankly, lawyers operate within a secular system that we have set up to enable a justice system that operates to enforce the laws of our community. It's entirely a secular process. It's not comparable to a religion that has set up its own practices and applies to a small group of people in a voluntary manner. Another matter that is raised, has been raised with us from the Church is in relation to the Catholic Church, in relation to the fact that the purpose of confession is, on their assertion, to get a person to change their behaviour. And I would state absolutely categorically it is immaterial for our purposes here as legislators as to the intent of confession as a practice. Entirely irrelevant. It is immaterial for our purposes as legislators as to whether the act of confession is successful or otherwise in its stated intent. We certainly have had significant questions raised for us through the Royal Commission process and otherwise as to whether the level of success in confession, getting people to change their behaviour, is even worth discussing. But for us, it's actually immaterial. It's immaterial for our purposes as legislators as to whether there would be people deterred from engaging in confession by removing the seal of secrecy, which has been put to us as a reason not to do it. That we shouldn't remove that seal of secrecy because then people might not come to confession and, by their logic, not have an avenue to change. It's immaterial to our purposes. Our focus is on secular laws relating to the prioritisation of vulnerable children and their protection, and nothing to do with a religious practice trumps that or should be put above that. My understanding, a further objection raised by the Archbishop of Tasmania was that priests cannot comply with the law and it would require them to violate their vows to a higher authority. We've also heard that this week from Victoria and the Archbishop there. Again, let me state quite clearly, it's our role to make appropriate laws in the best interests of our community, and it's not required that we make these laws in alignment with or support of any particular religious belief or practice. I would be interested to hear from the government later in terms of what implementation strategies, if any, could help us ensure priests don't ignore these laws. That could be helpful to consider going forward, but neither the argument that priests may not comply nor the argument that this will provide a barrier to people accessing the sacrament of confession offer compelling reasons to give us for us to give a continued exemption for mandatory reporting to the situation of the confessional. And let me just repeat that while I understand the sensitivity of this for people of the Catholic faith who see this as a sacrament in their faith, I believe fundamentally it is not incumbent on us as secular legislators to prioritise the preservation of their religious practice above our responsibility to act in the best interests of our community and especially in the best interests of vulnerable children. So for all those reasons, and because I believe it's excellent progress in that protection of vulnerable children, I support this bill and thank the government for bringing it to us.
The question is that the bill be read the second time. The honourable member for Hope.